Chapter 7 Parties to Suits in Chancery. Article I. WHO may sue in Chancery. Section 80. General rule as to parties. Complainant. Any person, natural or artificial, may bring a suit in the Chancery Court, except alien enemies, foreign executors and foreign administrators. Persons of unsound mind and infants must sue, however, by their regular guardian, or by a next friend, and married women must sue by next friend, except when they sue jointly with their negation bands, or sue after being deserted by their husbands, or sue for a divorce. The term artificial persons includes the United States, the state of Tennessee, the various counties and municipal corporations of the state, and all private corporations, and all partnerships, foreign and domestic corporations, public and private, foreign and domestic, sue in their corporate name, the name given them in the statute or charter of incorporation. Counties sue in their county name. The state of Tennessee sues in her own name, by her attorney general, or by her district attorney, and, where the suit concerns some individual or individuals more than the state, she sues in her own name by her attorney general, or her district attorney, on the relation of the individual or individuals interested. These individuals are named relators, they are the real complainants, and are, therefore responsible for the costs of the suit. Section 81. Suits by alien enemies, and foreign administrators and executors. Alien enemies are the citizens of a nation with whom the United States are at war. Such enemies, while residing out of the United States, can neither sue nor be sued in any court within the United States, but if they reside here, and are not forbidden by the general or state governments to remain, they are under no disability to sue or be sued, and have the same rights in court as alien friends. An executor or administrator appointed in another state can neither sue nor be sued in this state, as such, but if he brings assets into this state he may be held liable therefore as a constructive trustee. Section 82. How minors and persons of unsound mind must sue. Minors and persons of unsound mind, in consequence of their mental incapacity to attend to their business affairs, as well as their inability to bind themselves for the costs of the suit, or to make any contract relative thereto, are not allowed to institute a suit directly in their own names, and on their own motion. But as these persons frequently need the active interposition of the court to protect their interests, the court allows their guardians to institute suits in their behalf, to assert their rights, or to vindicate their wrongs. And if they have no guardian, or if the guardian himself neglects his duties, or is the person to be sued, the court will permit any person who is sui juris to bring suit in their behalf. This person is styled the next friend, or progeny, of the infant or person of unsound mind in whose behalf he sues. A person of unsound mind may sue by next friend, either before or after an inquisition of lunacy, but if he have a guardian he must sue by the guardian, unless the latter has violated his trust, in which case the non-compos may sue by next friend, making his guardian a defendant. A bill may even be filed on behalf of an infant unborn, inventus mere, by its next friend, when its interests demand, and in such a case, an injunction will be granted to stay waste on lands that will belong to the infant at its birth. A guardian appointed for a minor, or non-compos, in another state, cannot in strict practice sue here as such. Should he sue as such, however, the court will not repel him, but will recognize him as the next friend, and allow the suit to proceed to final decree, and then take the proper steps to secure to the infant the recovery, if any be decreed it. A person of unsound mind may file a bill and prosecute a suit in his own name, if the defendant fail to object thereto at the right time, and in the right manner. The court will not dismiss a suit brought by a person of unsound mind, at any stage, if a competent person will assume the office of next friend for him. Section 83. How married women must sue. On her marriage, many of a married woman's rights become vested in her husband, and as to many of her interests he becomes a sort of guardian, or next friend. Hence, in all ordinary cases, where it becomes necessary to bring suit for the protection of the wife's rights, she sues along with her husband. Besides, being unable to bind herself for the costs of the suit, it is necessary to have someone joined with her as complainant, who can be held responsible for the costs. Whenever there is no conflict between the interests of the wife and those of the husband, she must, ordinarily, sue jointly with her husband. But whenever there is a conflict, whenever the husband is asserting, or has asserted, claims inconsistent with his wife's rights, or has, by his own act, or neglect, debarred himself from protecting her rights, in all such cases he stands in the position of a guardian who has violated his trust duties, and his wife may file a bill by a next friend, making her husband, and all others who have wronged her, parties defendant. So, whenever the wife sues in reference to her separate property, she should sue by next friend, and her husband should be made a defendant. When the joint right of action of husband and wife to recover land belonging to the wife is barred, she may sue by next friend, and recover, making her husband a defendant. But no person can act as next friend for a married woman without her consent, unless she be a minor, also. Section 84. When a married woman may sue, or be sued, alone. The law of Tennessee is liberal to married women, and has emancipated them from some burdensome bonds of servitude. By the common law, on her marriage, all her legal rights became vested in her husband, and she could do nothing without his consent and guidance. The Court of Chancery first extended a helping hand to married women, by allowing them to sue by next friend, and now, by the aid of the statute, where a husband has deserted his family, his wife may prosecute, or defend in his name, any action, which he might have prosecuted or defended, and she may also sue, or be sued, in her own name, for any cause of action accruing subsequent to such desertion. She may, also, sue and be sued alone, when her husband has been declared insane by the verdict of a jury, and when it becomes necessary for her to file a bill of divorce. She may do so in her own proper person, and without any next friend. She may, also, sue or be sued alone, if her husband has permanently left the state, or is confined in the penitentiary, or is otherwise civilly dead. If a married woman is engaged in the mercantile or manufacturing business in her own name, or by agent, or as partner, she may be sued as a feme sole for debts incurred in such business, and cannot plead her coverture in such cases. It would seem from a general survey of our decisions and statutes, that it may be laid down as a general rule in Tennessee, that, whenever the wife is living separate from her husband without her fault, she may sue and be sued as a single woman. But if a married woman, who could otherwise sue or be sued alone, is a minor, or of unsound mind, she must sue by guardian or next friend, and must defend by guardian, or guardian ad litem, like any other minor, or non-compos. Section 85. Suits by persons under a quasi-disability. Deaf and dumb persons, if also very ignorant and incapable of being fully communicated with as to their property rights, may be allowed to sue by next friend. So may persons in their dotage, or imbecile adults, or any person not strictly non-compos and yet not able to manage his business affairs. If a person has religious scruples against being a party to a suit, he may sue by next friend. Article 2. WHO may be sued in Chancery. Section 86. General rule as to parties defendant. In general, it may be stated that every person, who may sue in the Chancery Court, may also be sued, and, in addition, all persons who may or must sue, by guardian or next friend, may be sued, for they cannot plead their disability in their defense. The only persons, natural or artificial, who cannot be sued, are, 1. The state of Tennessee, 2. Alien enemies residing out of the state in time of war, 3. Foreign executors and foreign administrators, and, 4. Public corporations created by and in another state for governmental purposes. It is sometimes said that bankrupts cannot sue, or be sued. The reason of this is, their estate, by operation of law, has become vested in their assignees, and they, therefore, cannot legally sue, or be sued, because they have no interest in the subject matter of the suit, and no decree can, consequently, be pronounced against them. What is meant by bankrupts not being able to sue, and not being subject to be sued is, that if they sue no decree can be rendered in their favor, and if they are sued, no decree can be rendered against them, if the fact of their assignment or discharge duly appear. But if a defendant fail to plead the bankruptcy of the complainant, or failed to plead his own discharge in bankruptcy, the suit will proceed as though no bankruptcy existed. Section 87. Suits against infants and lunatics. Minors, married women, and persons of unsound mind, may be sued, but, as they are incapable of defending a suit by themselves, they must make their defense through others not under any disability. Minors and persons of unsound mind defend a suit by their regular guardians, if they have such, but if they have no guardian, or if the guardian is a complainant, or is adversely interested, they defend by a guardian ad litem, appointed by the Chancellor, or the Master, for that purpose. Where a minor is, also, a married woman, it is nevertheless necessary that she should defend by a guardian ad litem, the practice being to appoint her husband to be her guardian ad litem, when he is a co-defendant, and there is no conflict of interest. Perhaps, however, a failure to have a guardian ad litem appointed for a married woman, who was a minor, but who joined with her husband in answering the bill, would not make the proceedings void as to her, if it appeared that she had full defense made for her, and was, in no way, prejudiced by not having a guardian ad litem. In such a case her husband would, no doubt, be deemed a de facto guardian ad litem. Section 88. Suits against married women. In regard to married women, ordinarily their husbands must be joined with them as defendants in the suit, and their answer must also be joint. There are exceptions, however, to the rule, in both of its requirements. A married woman may be made a defendant, and answer as a single woman, as, for example, whenever her husband is complainant in the suit, and sues her as defendant, for, in such a case, he elects to treat her as a single woman for the purposes of the suit. But, generally, a married woman cannot answer separately, when her husband is joined, or ought to be joined, as a defendant in the suit, without an order of court for that purpose, founded upon special circumstances. Thus, where a married woman is sued in respect to her separate estate, or where she claims as a defendant, in opposition to her husband, or lives separate from him, or disapproves of the defense which he wishes her to make, she may obtain an order of the court for liberty to answer and defend the suit separately, and in such wise her answer may be read against her. If a married woman obstinately refuses to join in a defense with her husband, the latter may obtain an order to compel her to make a separate defense. If the husband has, upon leave, answered separately, the wife may, upon order, afterwards file her separate answer. If the husband be abroad, and not answerable to the jurisdiction, the complainant in the suit may obtain an order, that she shall answer separately. Except under circumstances of this and a similar nature, a married woman can defend a suit only jointly with her husband, unless she is living separate from him in some of the cases stated in a preceding section. But if she is engaged in the mercantile or manufacturing business in her own name, or by an agent, or as partner, she may be sued as a feme sole for the debts incurred in the conduct of such business, and no plea of coverture will avail in such cases. Where the married woman is, also, a minor, she must defend by guardian ad litem, as before stated. But if a married woman is sued as a single woman, and fails to plead her coverture, a judgment or decree against her will be valid, and may be enforced against her general property, but not against her separate estate. Section 89. Suits against counties, cities and other corporations. Names stand for the things named, and we know things by their names. The law recognizes this, and allows all persons, natural and artificial, to be sued by those names whereby they are known. Counties are sued by their statutory names, as Shelby County, Davidson County, Knox County, and the like. Cities and incorporated towns are generally sued by their corporate names, being the name given them in the Act or Charter of Incorporation, but, as the complainant may not know the exact corporate name of a city or town, he may sue it by the name it is generally known by. Thus, if its proper name is the Mayor and City Council of Nashville, the city may nevertheless be sued as the City of Nashville. Private corporations may be sued by their corporate names, or by the names by which they are generally known in the community where they do business. The officers of a corporation may be made defendants along with their corporation, and required to answer under oath. when a discovery is sought. Article 3, General Rules as to Parties. Section 90. Principles applied in determining the proper parties. Courts of equity adopt two leading principles for determining the proper parties to a suit. 1. One of them is that the rights of no man shall be finally decided unless he himself is present, or at least has had a full opportunity to appear and vindicate his rights. 2. The other is, that, if the decision of any part of the subject matter of the suit will affect the present or contingent rights or interests of any person or persons, or, if a complete decree cannot be made upon all the matters involved, without having certain persons, or the interests of certain persons, before the court, then all such persons must be made parties, or their interests otherwise duly represented. It is the constant aim of courts of equity to do complete justice, by deciding upon and settling the rights of all persons interested in the subject matter of the suit, so that the performance of the decree of the court may be perfectly safe to those who are compelled to obey it, and also, that future litigation may be prevented. Hence the maxim, that courts of equity delight to do complete justice, and not by halves. And hence, also, it is a general rule in equity, subject to certain exceptions, which will hereafter be noticed, that all persons materially interested, either legally or beneficially, in the subject matter of a suit, must be made parties to it, either as complainants or as defendants, however numerous they may be. By this means the court is enabled to make a complete decree between the parties, and to prevent future litigation by taking away the necessity of a multiplicity of suits. When all the parties are before the court, the whole case may be seen, and full and complete justice done to all and in every particular, however various and conflicting their interests may be. Section 91. General Rules as to who should be parties. It may, therefore, be stated as a general rule, that all persons who have any interest in the subject matter of the suit, or who are liable to be affected by the decree prayed for, are proper parties to the suit. It matters not how small the interest, or whether that interest be legal or equitable, direct or remote, so that it is an actual existing interest. A mere possibility or probability of a future interest will not be sufficient. It must be borne in mind, however, that parties are necessarily made according to the charges in the bill, and not according to the result of the decree. If the bill show the parties to be proper, that is sufficient. All persons are proper parties who have any interest, legal or equitable, in the recovery sought, or who are in any way liable to be called on to satisfy the demands of those who complain. Persons who have the legal title to property in litigation, even though they have no beneficial interest therein, must be made parties, and so must all persons without whom a complete decree, disposing of all the various parts of the controversy, could not be made. Equity delights to do justice in full and not by halves, and acting on this maxim, the court requires the complainants to bring before it every person necessary to enable it to so completely determine the matters in dispute that no further litigation will be necessary. This requirement is the price of the relief to be granted. Whenever a person, if living, would have been a proper party, his privies in estate must be made parties. If his personal estate is involved, his personal representatives must be made parties. So, if a person would have been a proper party had his interests continued in him, his privy in estate must be made a party in his place, whether such privy be an assignee, or a purchaser at an execution, or other, sale. Whenever a trust estate is liable to be affected by the decree, both the beneficiaries and trustee should be made parties, and whenever the rights of a wife are involved in the litigation, she and her husband must both be made parties, unless the husband has wrongfully abandoned the wife, in which case she may sue or be sued alone. Inasmuch as the wife has an interest in the homestead, which she may assert in court, both against her husband and his bargainees and creditors, it is always prudent to make her a defendant, along with her husband, in all suits brought to recover possession of the homestead, or to divest the title thereof out of him, or to sell the same, or to enforce any lien, claim or right thereto. If she is not made a party, no decree against her husband will bind her, and she may relitigate the question of homestead, or any other right in, or to the land, after final decree against her husband. A bill to effect an equity in land or personalty must make the holder of the legal title a party, and, on the other hand, A bill to effect the legal title must make the owner of the equitable title a party, if any there be. Section 92. Exceptions to the general rules as to parties. In the first place, it must be always remembered that courts of equity observe general rules, only insofar as they contribute to the attainment of justice, and they struggle against technical rules which impede its power to do justice. It is manifest that a general rule, established for a proper administration of justice, ought not to be adhered to in cases where it would defeat justice, for then it would destroy the very purpose for which it was established. Therefore, the general rule that all persons interested must be made parties, is not adhered to. 1. Where the parties are unknown, and cannot be ascertained upon diligent inquiry, in which case they must be made defendants by description, as hereafter shown. 2. Where the parties are numerous, but the general rights of those entitled to relief are the same, in which case one or more of them may sue on the behalf of all. 3. Where the parties are very numerous, so that it would be impracticable to make them all parties, without thereby causing almost interminable delays, by reason of deaths, marriages and transfer of interests, but in such case provision is made to secure the rights of those not actually made parties. 4. Where parties not in being are liable to be affected. It sometimes happens that persons not in being, not in se, are interested in property which the interest of parties in being required to be brought before the court. In such a case the bill may be filed by or against the interested persons in being, in se, and the decree will be binding on those not in being. All the interested persons in being must be made parties, both life tenants and remainder men. If no remainder man be in being, then the life tenant must be made a party, in which case the remainder men will be bound by the decree, they being represented by the life tenant. Thus a decree of partition among tenants for life, with remainder to unborn sons, will be binding on the sons when born. In all such cases, however, all the parties interested who are in being must be before the court. But in all these exceptional cases, so solicitous is the court to attain the purposes of substantial justice, that it will generally require the bill to be filed, not only in behalf of the plaintiff, but also in behalf of all other persons interested, who are not directly made parties, so that they may come in under the decree, and take the benefit of it, or show it to be erroneous, or entitle themselves to a rehearing. The court will go further, and in such cases, it will entertain a bill, or petition, which shall bring the rights and interests of the absent parties more distinctly before the court, if there is any certainty, or even danger, of injury or injustice to them. In all the foregoing cases, the bill should show a state of facts bringing the suit within one of the exceptions to the general rule. It may here be remarked, that the general rule requiring all persons interested to be made parties, is not so much a right of the parties brought before the court, as a rule prescribed by courts of equity, themselves, founded on their notions of public policy, on their anxiety to do justice to all persons interested in the subject matter of the litigation, and on a desire to prevent future controversies. Section 93. Who are proper, and who necessary parties. A distinction exists between proper parties, and necessary parties. Proper parties are those whose interests in the matters involved in the litigation are such that a decree may be properly pronounced without their being before the court, whereas, necessary parties are those without whom no complete decree can be made. 1. Necessary parties are, 1. Those who are entitled to share in the benefits of the relief sought. 2. Those who are indebted to the complainants, or who are withholding from them their legal or equitable rights, or property. 3. Those who are doing, or attempting to do, complainants some injury. 4. Those who have legal or equitable titles or claims adverse to those set up by the complainants. 5. Those who hold titles or interests which, if not bound by the decree, might cloud the title of the complainants, or that of the purchaser at the master's sale. And 6. Those having any interest in the subject matter of the litigation, present or contingent. 2. Proper parties are, 1. Those against whom some of the defendants, if held liable to complainants, would be entitled to judgment over. 2. Those whose rights in the subject matter of the controversy have terminated, but no proper evidence thereof has been given. and the complainant's desire to conclude those rights by the decree. 3. Those who, while not liable to complainants or to their co-defendants, have claims, admitted to be inferior to those of complainants, which should be bound by the decree to clear up the title, or adjust all equities. In determining whether a particular person is a necessary party or not, it must be considered, 1. Whether, if he should be omitted, the complainant could obtain all the relief he seeks. 2. Whether, if he should be omitted, he could relitigate any of the matters the bill seeks to have adjudicated. And, 3. Whether, if he should be omitted, and the property in dispute is sold, he could, either at law, or in equity, disturb the title of the purchaser. If either of these questions be answered in the affirmative, such person is a necessary party, otherwise he is not. Where there is doubt whether a certain person is a necessary party, the safer rule is to make him a defendant, and thus leave the question to him and the court to determine. Section 94. Who are not proper parties. As a rule, a person who has no interest whatever, legal or equitable, in the subject matter of the controversy, and for or against whom no decree in reference thereto can be pronounced, is not a proper party. To constitute a person a proper party, he must be so connected with the matter in dispute as 1. To be entitled to have something beneficial decreed him, some relief granted him, or 2. To be under some obligation to the complainant capable of being enforced, or 3. To have some estate in him, legal or equitable, real or apparent, liable to be divested out of him for the complainant's benefit, or 4. To be doing some act to complainant's injury subject to injunction, or 5. To have some right involved in the controversy necessary for him to protect or enforce, or necessary to be determined. Persons against whom no relief is prayed are not proper parties, nor are mere servants, agents, auctioneers, attorneys, arbitrators, sheriffs, clerks, constables, or other officers issuing or executing process, proper parties, unless they have done, or are doing, acts entitling the complainant to affirmative relief against them. It sometimes, however, becomes necessary to make such persons parties in order to give them authoritative notice of an injunction restraining them. Tenants claiming under a party to the suit, and mortgagers who have conveyed all their legal and equitable interests in the estate, are not, ordinarily, proper parties. But there is a class of persons who have an interest in the property before the court, and yet who are neither necessary nor proper parties to the suit. This class includes persons who have an interest in the subject matter of the suit, but whose title is paramount to that of the complainant, and against whom, or whose title, the complainant is entitled to no relief and seeks no decree, such as 1. Prior mortgagees in a foreclosure suit, 2. Owners of the fee in a suit for possession between tenants and subtenants, and 3. The remainder man in a suit between the tenants for life relative to their rights. The persons having these paramount titles are neither necessary nor proper parties. Subsequent mortgagees are proper parties, but not necessary parties. Nevertheless, it is well to make them parties in order to conclude their rights and extinguish their claims by the decree. Section 95. Summary of the rules as to parties. The following is a summary of the general rules as to parties in equitable suits. 1. All persons may sue and be sued, but persons under disability must sue and be sued through persons not under disability, with some exception in case of married women. 2. All persons having any interest or title, legal or equitable, in the subject matter of the suit, or liable to be beneficially or injuriously affected by the relief sought, are proper parties, unless they are very numerous, in which case some may sue or be sued in behalf of all, when it can be done without injustice to any. 3. All persons beneficially interested in the relief sought may join as complainants. All other persons should be made defendants. Persons under disability should ordinarily be made defendants, unless they are specially complaining of violations of their rights. Article 4. WHO should be complainants. Section 96. General rules as to parties. Complainant. All persons who have a beneficial interest in the relief to be sought may join as complainants. It is not necessary that the interest of the complainants should in every instance be identical. A community of interest is, generally, all that is requisite. There must, however, be no incongruity in their claims, for a joinder of complainants with distinct, inconsistent and hostile claims and grounds of relief, would lead to much inconvenience and confusion, and will not be allowed by the court. Neither can complainants join in a suit on the ground that if some of them are not entitled to recover, the others are entitled, but the bill must show on its face that each and all of the complainants are interested in the relief sought, and have a right to the same, although their proportions of the recovery may be different. A mere spark of right in a party, without any beneficial interest whatever, will justify making him a co-complainant when the little right he has is consistent with the rights of the other complainants. All persons having the same interest, or seeking the same relief, may join as complainants in the same bill. Indeed, they should join, if the consent of all can be obtained, unless their number is too great, and then, as elsewhere shown, one or more may sue in behalf of all. Whenever a person who may, or should be, a complainant refuses to join in the suit, or is out of reach so that he cannot be consulted, he must be made a defendant. The rule that persons claiming under different titles cannot be joined as complainants in the same suit does not apply to cases where their titles, though distinct, are not inconsistent with each other. Thus, all the creditors of a decedent may join as co-complainants to have his assets properly administered, although they claim under distinct titles. So, two or more persons may unite to enjoin a nuisance injurious to all. Section 97. Who should be complainants when the parties are very numerous? As already shown, the court does not require all of the persons interested in a suit to be made parties, when it is impracticable. If the persons interested are too numerous to be all brought before the court will not insist on their being made parties, but will allow one or more to sue in behalf of their entire class. Cases of this character may be divided into three classes. 1. Where the question is one of common or general interest. In such a case one, or more, interested in the relief sought, may sue for the benefit of all. This class includes creditors of a decedent, creditors of a fraudulent vendor, creditors who are parties to a deed of trust, legatees under a will, distributees of the estate of a decedent, and creditors of an insolvent partnership, or of an insolvent corporation, and indeed, all persons interested in the distribution of any fund, especially a trust fund. 2. Where the persons interested are members of a voluntary association. This association may be for either public or private purposes. In cases of this sort, a few may sue for the benefit of themselves and all the others, care being taken to have a due representation of all substantial interests before the court. This class includes literary and social clubs, unincorporated insurance, labor, political, charitable, and religious associations, and all sorts of voluntary societies for pleasure or improvement, partaking somewhat of the character of a partnership. In cases under this subdivision, suits may be brought against a few of very many members of such societies, clubs and associations, care being taken to make defendants of those who fairly represent the interest of all. In such case it would be well to make defendants, 1. Of the managers, executive committee, or other directory of the society, if any exist, or, 2. Of the committee who incurred the liability sought to be enforced. The bill should charge that the members of the society are numerous, and many unknown, and should give the reason for suing the defendants in particular. 3. Where the parties are numerous, but have common rights or interests. In this class there is usually a privity of interest between the parties, but such privity is not essential. There must, however, be a common interest, or a common right, which the bill seeks to establish, and enforce, or a general claim, or privilege, which it seeks to establish, or to narrow, or to take away. In such cases, a few may sue in behalf of themselves, and all others standing in the same predicament, the court taking care that sufficient persons are before it to fairly and fully ascertain and determine the general right in contest. Section 98. All parties having concurrent interests should be co-complainants. All persons who have a right to partake of a general recovery should join as complainants in prosecuting a suit to obtain such recovery. There are several reasons for this rule. 1. It simplifies the examination and cross-examination of witnesses to have the parties all properly marshaled, those having the same interests all standing on one side. 2. It makes the argument and the hearing more orderly. 3. It enables a decree to be drawn more logically and with less verbiage. 4. It has the effect to better apportion the burdens of the litigation, and to lessen the costs, and 5. It enables both sides to prepare their cases with more accuracy, speed, and general satisfaction. In suits to recover personal property, all of the joint owners must join as complainants, and in suits to enforce any joint right, joint obligation, or joint claim, all the joint owners must join as complainants or give some good reason for not so doing, in which latter case the joint owner not suing must be made a defendant. All the joint owners of a fund should join in a suit for its recovery. All partners, joint trustees, joint executors, and joint administrators must join in a bill filed to assert their claims as such. Section 99. How husband and wife sue and are sued. Husband and wife, although one in law, are two in equity, especially when the separate property of the wife is concerned. In law the husband may sue alone, and in his own name, for all personal property or contract rights accruing to the wife, or to the husband and wife jointly, during marriage, but in courts of equity, in all cases in which the husband seeks to recover the property of his wife, he should join her with him as co-complainant, whether the right to the property accrued before or during marriage. The reason of this rule is the parental care courts of equity exercise over persons under disability, and the necessity of guarding the wife's equity to a settlement. But when it is necessary for her to sue alone, as stated elsewhere, she must sue, ordinarily, by next friend, making her husband a defendant. Whenever there is any antagonism of interest between her and her husband, whenever her husband, by his acts or negligence, is estopped or barred of his right to sue along with his wife for the assertion of her rights, she may sue by next friend, making the husband a defendant. When the husband has deserted his wife, or has been adjudged a non-compos, she may both sue and be sued as a single woman. Whenever the wife is sued, her husband must ordinarily be made a defendant along with her, even if she is sued as an executrix, unless he has deserted her, or is adjudged a non-compos, or she is sued on a debt incurred by her in a mercantile or manufacturing business, when she may be sued as a feme sole. And as a wife can sue her husband in the Chancery court whenever her separate interests require, so a husband may sue his wife in the same court when his separate interests so require. Article V. WHO should be defendants. Section 100. General rule as to parties. Defendant. All persons against whom relief is sought, or who are interested in resisting the relief sought, must necessarily be made defendants, as must, also, all others whose interests in the subject matter of the suit are adverse to, or inconsistent with, the interests of the complainants. All persons claiming any title, legal or equitable, to the property in controversy, must be made defendants, if such title is in conflict with the title set up by the complainants. All persons whose rights are concurrent with those of the complainants, but who have not consented to become complainants, must be made defendants. And, in general, all persons interested in the subject matter of the suit, or liable to be affected in any way by the decree sought, whether their interest or liability be legal or equitable, who do not join as complainants in filing the bill, should be made defendants. Section 101. When parties under disabilities should be made defendants. Although lunatics may appear by attorney when suing or being sued, nevertheless, when there is a choice of position in suits affecting their interests, they should be made defendants, and should defend by guardian ad litem when they have no regular guardian. The same rule applies to minors, with, perhaps, even greater force. The reason of this rule is, the court can better guard the interests of minors when defendants than when complainants, and, besides, the attitude of a defendant in a suit in equity is, in various respects, more advantageous and safe for infants than that of a complainant. Nevertheless, it is not reversible error to join a non-compos or a minor as complainant in a suit necessary to assert their rights, they, of course, suing by guardian, if they have one, otherwise by next friend. A lunatic may sue, or be sued, in person, and may appear or defend by a solicitor of the court, like a person sui juris. But the more prudent course is to have them sue by next friend when they are complainants, and defend by guardian ad litem when defendants. Section 102. Suggestions as to whom to make defendants. In determining who should be made complainants and who defendants to a suit in Chancery, the draftsman of the bill should ascertain: 1. Who are the persons to be benefited by the relief sought? 2. Who are the persons against whom the relief is sought? And 3. Who are the persons, if any, having rights, legal or equitable, without beneficial interests, liable to be affected by the decree? 1. The first class includes all who have a right to be benefited by the decree prayed for, and if there be no conflicts in their respective interests, they may all be joined as complainants, and should be so joined, if their consent can be obtained. If such consent cannot be had, they must be made defendants. 2. The second class includes all persons against whom relief is sought, all persons liable to the complainant's demands, primarily or secondarily, all persons charged with doing complainants some wrong, or withholding some right. This entire class must be made defendants, unless there be some special reason for not suing them, such as their death, insolvency, or absence from the state, which reason should be stated in the bill. If there be any remainder men not in being, or any other person not in being, having a contingent interest, the life tenant must be made a defendant to represent them. 3. The third class includes all those having dry titles, legal or equitable, without any beneficial interest, to the property in litigation, such as holders of the naked legal title, dry or naked trustees, absolute assignors of a non-negotiable thing, mortgagers, who have informally assigned their entire equity of redemption, mortgagees under an absolute deed whose debt has been fully paid, or wholly transferred, and, in short, all persons who, while in no particular default, are nevertheless so connected with the subject matter of the litigation that they should be bound by the decree, either to wholly determine all the various branches of the controversy, or to perfect the title to the property before the court. All persons belonging to this third class may be made defendants, if, however, there be no conflict between the rights and interests of the first and third classes. The persons in the latter may be joined as co-complainants, but, as a rule, the better course is to make all persons in the third class parties defendant. If the persons seeking benefits under the decree sought have adverse or conflicting interests in the subject matter of the suit, or in the relief sought, they cannot join as co-complainants, and one set or the other of those having conflicting interests must be made defendants. For, in a lawsuit, as in a battle, assailants cannot engage in a conflict between themselves, and make a successful assault on their adversaries. At the same time, there must be a community, or, perhaps more correctly speaking, a congruity of interests among the complainants, and their cause of action, or right of recovery, must be substantially the same, although their proportions of the recovery, or their interests therein, may be unequal. And, as a rule, there must be a common source of title or interest, or at least some bond of union, between the various complainants, such as exists between joint heirs, between partners, between tenants in common, between joint trustees, between joint executors, or joint administrators, between the creditors of the same estate, between the wards of the same guardian, between the beneficiaries under the same trust, between the legatees or devisees under the same will, between the sureties on the same instrument, between the payers or payees of the same obligations, between the parties to the same contract, bond, or deed, between members of the same association, or corporation, and, generally, between the persons subject to the same general burden, or entitled to share in the same general benefit. On the other hand, there need be no community or congruity of interests among the defendants. They may, and often are, adversely concerned among themselves, or liable in different amounts, in different degrees, and on different accounts. Indeed, some of the defendants may have the same rights of recovery and general relief as some of the complainants, or may have other affirmative rights against some of their co-defendants, and may be entitled to a decree against some of them, either in the first place, as though they were suing as complainants, or, in the second place, because they are only liable to complainants in case of default by their co-defendants. To illustrate this, one of several wards, who has had several guardians, may sue all of his guardians, and all of their sureties, in one suit, and may make the other wards defendants. In such a case, the court may decree in favor of the defendant wards, as well as the complainant, and may, also, decree the primary liability of the obligees on some of the bonds, and decree against them in favor of the obligees only secondarily liable, the pleadings so permitting. Section 102. Sometimes, it cannot be ascertained at the institution of a suit whether a certain person is a necessary party or not. His rights, or liabilities depending for their existence upon the adjudication itself. In all such cases, the person should be made a defendant. Thus, on a bill to enforce a vendor's lien, after I because there may be a surplus after the debt and the vendee's death, the widow may have an interest, costs are paid. Edwards v. Edwards, 5 Heisk, 123. Article vi. Next friends and guardians ad litem. Section 103. Next friends, generally considered. A next friend, or, as he is frequently termed, a prochnomy, is a sort of self-appointed guardian who assumes the duty and responsibility of bringing a suit in behalf of a person under some disability, legal or natural. The person thus under disability, is generally, 1. A married woman, or 2. A minor, or 3. A person of unsound mind. These persons not being able to bind themselves by contract for costs of suit, and, in case of minors and persons of unsound mind, not being of sufficient mental capacity and business experience to comprehend their rights and how to protect them, it becomes necessary for some friend to intervene in their behalf, whenever their interests require the interposition of a court. This friend is called the next friend, because formerly he was the nearest, or next, kinsman of the person under disability. But, now, any person may act as next friend, provided he is acting in good faith, and secures the costs. The object of the rule requiring a next friend in the prosecution of suits for the benefit of persons under disability, is to have someone responsible for costs and liable to judgment therefor, and to have someone upon and against whom the court may make and enforce its orders, and who will be subject to punishment for contempt in case of disobedience to, or violation of, the mandates of the court, and for the more especial purpose of having someone before the court capable of looking after and caring for the interests of those incapable of understanding and defending their own rights. It is the duty of a next friend sedulously to watch and protect the interests of his ward involved in the litigation. He is, in the conduct of the suit, subject to the control of the court, and if he fail to do his duty, or if any other sufficient ground be brought to the knowledge of the court, as, if he have an interest in the litigation antagonistic to the interests of his ward, the court not only has the power, but it is its duty, to remove him, and appoint another, who may be more faithful, or not subject to a similar temptation. Were the rule otherwise, the ends of justice might be defeated, and iniquities perpetrated by a party, whose interests are antagonistic to those of his ward, assuming the office of next friend, and bringing his ward before the court, in order, through the forms of law, to rob it of its just rights and at the same time accomplish his own avaricious purposes. The next friend is deemed an officer of the court, and the minor a ward of the court. If two suits are brought by different persons, acting as next friends, the court will allow that one of them to be preceded in which, on inquiry, appears most to the ward's benefit, and will stay proceedings in the other. If the ward's disability should terminate during the pendency of the suit, he may elect whether he will continue it, or abandon it, but if he abandons it he will be taxed with the costs, unless the court should be of opinion that the bill was improperly filed, in which case the costs will be adjudged against the next friend. The next friend of a minor cannot receive the money on a judgment he recovers for his ward, nor can he confess satisfaction thereof. A next friend cannot elect for a person under disability, and the court will not, unless the record enables it to make an intelligent and effectual election, nor can a next friend compromise a suit, or receive or receipt for the amount due his ward, or collect or compound the debt recovered by suit, or submit a case, pending in court, to arbitration. The next friend generally signs and swears to the bill, unless his ward better knows the facts, and then the latter may sign and swear to it. If a next friend dies or becomes incapacitated to act, pending a suit, a new next friend may, on motion, be substituted in his stead with the consent and approval of the court. Section 104. Next friends of married women. The general reasons already given for requiring a married woman to sue by next friend, and the reasons stated in the books, show that the principal, if not the sole, object is to secure payment of the costs that may be adjudged against her. A next friend of an infant may sue without obtaining the latter's consent, but the next friend of an adult married woman cannot. The married woman may change her next friend, on giving bond to indemnify him against the costs he has incurred, provided she be of age and the court consent. In view of this state of the law, and of our statutes in behalf of married women, and considering the fact that the next friend of an adult married woman is generally appointed by the wife, and is often a mere nominal party except as to costs, it is suggested that an adult married woman, who gives security for costs, may prosecute a suit in her own name, when it is necessary to do so to protect her separate interests against her husband. Courts of Chancery regard substance, not form. Section 105. Next friends of minors and lunatics. Although the practice of allowing infants and persons of unsound mind to sue by their guardian, describing him as such, prevails in this state, still he is in all respects a next friend, and is charged with all the duties and liabilities, is subject to the same restraints, and bears the same relation to the infant, or non-compos, and to the suit, as though he had been described as his next friend. The distinction, however, is more formal than material. If it be to the interest of the ward to have the guardian considered as a next friend, he will be so deemed. The Chancery Court of this state has full and original jurisdiction of the persons and estates of minors and persons of unsound mind, and may appoint, or remove, guardians whenever the interests of the minor, or non-compos, require such action. While it is certain that a minor must sue by guardian, or next friend, the rule that the same necessity exists in case of a person of unsound mind is not so inflexible. The reason seems to be the difficulty that sometimes exists to determine whether a particular person is of sound or unsound mind. If no objection is interposed, a non-compos may maintain a suit in his own name, and without guardian, or next friend, and if the objection should be made, and no one will assume the role of guardian, or next friend, the court would hesitate long before dismissing a meritorious bill for want of a next friend, especially if the costs were secured, and a solicitor of the court was acting as counsel for the non-compos complainant. Where a bill has been filed in the name of an infant, his coming of age is no abatement of the suit, but he may elect whether he will proceed with it, or not. If he goes on with the cause, all future proceedings may be carried on in his own name, and the bill need not be amended or altered. He will also be liable to all the costs of the suit, in the same manner that he would have been had he been of age when the bill was originally filed. If he chooses to abandon it, he may move to dismiss it on payment of costs by himself, but he cannot compel the next friend to pay the costs, unless it be established that the bill was improperly filed. Thus, when an infant, on attaining the age of 21 years, moved to dismiss a bill filed on his behalf, with costs to be paid by the next friend, the court refused to make the order, but directed the bill to be dismissed on the late infant, plaintiff giving an undertaking to pay the costs of the next friend. No doubt, the same rule would apply in case of a bill by a next friend of any other person under disability, in case such person's disability should terminate while the suit was pending. Section 106. Guardians ad litem generally considered. Defendants who are minors, or of unsound mind, are the wards of the court, which must represent them in the procurement of counsel, and in discharging this duty the court should select men learned in the law, and capable of taking care of the interests of their wards, and the person so chosen should, of course, have no interests antagonistic to those of his ward. If the minor, or non-compos, has a regular guardian, he must appear and defend by such guardian. No step can be taken against a minor, or non-compos, until after the appointment of a guardian ad litem. The appointment must not only be made, but it must be accepted. The complainant is not a proper party to nominate a guardian ad litem, but he may move the chancellor, or master, to make an appointment. No appointment can be made until after the minor, or non-compos, has been duly brought into court by service of process, or by publication, and he is not in court until the return day. It is not necessary for the minor to actually appear in court, in person, when sued, unless the bill is filed by his guardian to sell his property, and he is over 14 years of age. If, at the appearance term, or at the appearance rule day, no friend of the minor moves to have a guardian ad litem appointed for him, such guardian may be appointed by the Chancellor, or Master, on application of the complainant, supported by an affidavit that the minor has no general guardian. Where a married woman is a minor, she must defend by a guardian ad litem, like any other minor, but in such case her husband may be appointed when he is an adult and a co-defendant. Section 107. Powers, duties, and liabilities of guardians ad litem. The powers and duties of a guardian ad litem are limited, and strictly confined to the defense of the particular suit in which he is appointed. He is to defend the suit in the court from which he derives his authority, according to the rules and principles of law applicable to the case, as administered in that tribunal, and in conformity with the ordinary mode of trial and practice of the court in similar cases. It is not within the scope of his authority, or duty, to consent to change the tribunal for the trial, or that the decision shall be upon principles other than those applicable to like cases, in the forum in which the suit is pending. He has no power to submit the case to an arbitration, but he may exercise a sound discretion in reference to mere matters preliminary to a trial, and which cannot, ordinarily, affect or prejudice the merits of the case, or the interest of the minors, such as waiving notice of copy of bill, and agreeing to a reviver. He cannot, however, waive service of process on his wards, nor make them parties to the suit, because there can really be no lawful appointment of a guardian ad litem until the return day after service of process on the minor, or non-compos. A guardian ad litem is not expected to assume any affirmative responsibilities. His duty is to guard the interests and rights of his ward. The court in appointing him gives him a shield, but no sword, and if in the progress of the suit he thinks a cross bill should be filed, or other affirmative step taken, he should by affidavit, petition, or, if the facts are already of record, by motion, take counsel of the court in the matter, and get the court's leave before he acts further. On filing a cross bill, the guardian ad litem, pro hac vice, becomes next friend of the infant. He cannot bind his ward by admissions, but may consent to any hearing at chambers, and may waive formalities. He may consent to take evidence without the usual notice, and may consent to other matters relating to the conduct of the cause. But he should be cautious about such consents, and should submit to the court every question involving the rights of his ward. He must make as vigorous a defense as the law, and facts, and his ward's interests will justify, and should not delay the cause by failing to put in his pleading, or his proof, or to take other proper steps. Courts expect of guardians ad litem a faithful and diligent compliance with their duties, and for any gross failure therein they may be held liable to their wards for all damages sustained, and may be taxed with costs. Section 108. Some practical suggestions to guardians ad litem. The first thing a guardian ad litem should do, after his appointment, is to examine the subpoena or publication notice, to see whether his ward is properly in court, because, if the ward is not properly before the court, the appointment of the guardian ad litem is a nullity, and all the proceedings in the cause, so far as the ward is concerned, are absolutely void. The guardian ad litem owes this duty, 1. To the court, whose trusted officer he is, 2. To his ward, whose interests he is bound to guard, and, 3. To himself, as an evidence of proper diligence on his part, and as a precaution against the humiliation that would result to him from proceeding in the cause when his ward is not before the court. The second duty of the guardian ad litem is to thoroughly possess himself of the facts of the case, so that he may know what are the rights, what the duties, and what the interests of his ward. This duty is not performed by merely reading the bill, and making some general inquiries of the complainant's solicitor. He should consult persons who are friendly to the ward, and who know the facts of the case. If the ward is old enough to understand the matters in litigation, and is accessible, and his interests, rights and duties are proper matters to be submitted to him considering his age and judgment, the guardian ad litem may consult him, especially if he is near his majority. Having ascertained the facts, The guardian ad litem will then take such steps as will best promote his ward's welfare. If the object of the bill is promotive of that welfare, he should not put any obstacles in the way of the relief sought but should rather cooperate with the solicitor of the complainant in expediting the cause and making the costs as light as possible, especially if the ward may be liable for any part of such costs. If, on the other hand, the relief sought is detrimental to the rights and interests of the ward, the guardian ad litem should vigorously resist that relief, and in every proper way assert the rights and protect the interests of his ward, using for that purpose every available defense, admissible in equity, and should rally to his aid the relatives and friends of his ward, and should take every other step that is incumbent on a faithful, diligent, skillful and zealous solicitor and guardian. Article 7. Misjoinder and non-joinder of parties. Section 109. Who are parties to a suit in Chancery? The general rule is that no persons are considered parties to a suit except the complainants and the persons against whom the process is prayed. The mere naming a person as a defendant does not, however, make him a party. He must also be served with a process, unless he puts in a voluntary appearance. In drawing bills, the names of the parties, and their position as complainants and defendants should be clearly stated. In some bills it is difficult to ascertain who are intended to be made parties. The code form of giving the names should be adhered to. It is better than any yet devised by inexperienced draftsmen. Section 110. General rules as to defect of parties. It is manifestly impossible for a court to do full justice in a given case, unless the proper parties are before the court in that particular case. The court must both have jurisdiction and must hear, before it can determine. And how can it hear or determine when the person entitled to speak has never been brought before the court? This deficiency of proper parties is termed non-joinder. On the other hand, the complainants may be setting up a joint right of recovery against the defendants when not entitled to a joint recovery. Some of the complainants may have a right of recovery in the given case, but the others may have no right whatever to share in that recovery as joint owners thereof along with their co-complainants. Or, some of the complainants may have a right to recover on one account, and other complainants may have the right to recover on another and wholly different account, neither set of complainants having any interest in the other's cause of action, and no privity or community of interest existing between them. This failure of all the complainants to have a community or congruity of interest entitling them to share in the recovery, or the relief sought, is termed misjoinder of parties. Complainant. Again, persons may be joined as defendants for or against whom no relief can be granted, they being neither necessary nor proper parties, having no interest of any sort and being in no way chargeable. In such case, there is a misjoinder of parties. Defendant. The rules, therefore, are 1. That no person should be made a complainant, who has no community or congruity of interest with the other complainants in the general relief sought. 2. That no person should be admitted as a party, when no complete decree adjudicating all the matters in controversy can be made without him, either as complainant or defendant. 3. That parties representing interests wholly inconsistent cannot join as complainants. Co-complainants must have some general community of interest in the subject matter of the suit, and 4. That no person can be properly joined as a defendant, for or against whom no relief can be granted, nor decree rendered. Misjoinder of parties is a matter closely allied to multifariousness, and will be further considered under that head. Section 111. Effect of the non-joinder of parties. If all the parties, who should be before the court, are not made parties, upon the question being raised by demurrer, plea or answer, the court will allow the bill to be amended, or may pronounce a decree saving the rights of the parties not before the court, and it would be reversible error for the court not to permit an amendment, so as to bring in the necessary parties, even after allowing a plea, or demurrer, for want of parties. When such plea, or demurrer, is sustained, the complainant has the right, as a matter of course, to so amend his bill as to cure defect in it. If, at the hearing, it appears that persons interested have not been made parties, the court, as already shown, may allow the bill to be amended, or may render a decree, saving the rights of persons not made parties. The general rule, requiring all persons in interest to be made parties to the suit, is, in most cases, not a right of the parties brought before the court, but rather a rule prescribed by courts of equity for their own government, a rule founded in their anxiety to do justice among all parties having an interest in the subject matter, or in the object of the suit, and thereby to prevent future controversy and litigation. Courts of Chancery struggle against technical rules which impede the attainment of substantial justice, and will allow new parties to be made at almost any stage of the suit. Nevertheless, the Chancellor should be exceedingly slow to pronounce a decree, without having all the necessary parties before him, and should require the necessary amendments to be made to bring into court all the parties omitted, to the end that a complete decree may be pronounced, settling all the various legal and equitable rights involved in the litigation. Section 112. Effect of the misjoinder of parties. When a defendant is misjoined as a party, the nature of the controversy being such that no relief can be granted for or against him, he can have the suit as to himself dismissed, on motion or on demurrer, but no other party can object. If there is a misjoinder of complainants, however, any or all of the defendants may demur, and the bill, under the old rule of practice, would, thereupon, have been dismissed. But this rule is now greatly modified, and under the liberalized practice and rules of pleading of the present day, it requires a very flagrant case of multifariousness or misjoinder of parties to defeat, on demurrer, a clear equity, and the better practice in a doubtful case of misjoinder of complainants now is, to retain the cause in court until the hearing, and then dismiss it as to those complainants only not entitled to share in the recovery, or, the court may, in a proper case, authorize amendments, or even direct separate bills to be filed, without new process as to the parties before the court. It is now harshness, almost arbitrariness, for a Chancellor to dismiss a bill on a demurrer for misjoinder of parties when a clear equity, or legal cause of action, appears on the face of the bill, in favor of some of the complainants. Article 8. Effect of death or marriage of parties, or assignment of their interests. Section 113. Effect of the death of a party. Inasmuch as some confusion sometimes arises in the mind of junior counsel, by reason of the death, or marriage of parties, or a transfer of their interests, either before or after the bringing of a suit, it may be well to consider the effect of such occurrences on the death of a person, who, had he lived, would have been a proper party. Those who succeed to what would have been his rights or duties, must be substituted for him. If his personal estate would have been benefited or injured by the litigation, the representative of his personal estate, his executor or administrator, must be made a party. If his real estate would have been lessened or increased by the litigation, the representatives of his real estate, his heirs, must be made parties. Or if he left a will devising to anyone the particular real estate involved in the litigation, such devisee must be made a party instead of the heirs. If the real estate be devised for any purpose to the executor, he must be made a party. If the real estate is devised in trust, both the trustee, executor, or other person, specified in the will, and the beneficiaries must be made parties. In short, if the suit is to recover a debt, or personal property only, for or from the decedent, then his personal representative, administrator or executor, must be substituted for him. If the suit is to recover, or clear up title to, land only, claimed by the decedent, then his real representative, heir, devisee, or trustee and beneficiaries, must be made parties in his place. Of course, if the suit involves both the personal and the real estate, as it often does, then both the personal and the real representatives must be made parties. Thus, the heirs are necessary parties in a suit to recover the land, and the administrator is, also, a necessary party if the same suit seeks to recover rents accrued in the decedent's life. These same rules apply when a party dies pending the suit, in which case the suit must be revived against the same persons, successors in interest and estate, as would necessarily have been made defendants had the death occurred before the bringing of the suit. When personal or real representatives are made defendants in place of a decedent, they must all be made the defendants, as less than all do not represent him. If a party dies, whose personal estate is involved, and no one will administer on his estate, his heirs may revive if he was complainant, or the suit may be revived against his heirs if he was a defendant. When a suit is so revived, all the heirs must be made parties. But, as elsewhere shown, A foreign administrator or foreign executor can neither sue nor be sued. As such, in this state, where real estate belongs to a partnership, on the death of one of the partners the title vests in the survivors, and does not go to the heirs. The law regarding the partnership as a person that lives as long as any member lives. Hence, in a suit affecting partnership realty, the death of a partner does not affect the litigation, but it proceeds without the necessity of any reviver. Section 114. Effect of the marriage of a female party. Upon the marriage of a female party, her husband, by operation of law, becomes the owner of her personalty, and succeeds to all her rights thereto. Hence, he must be brought before the court, in order to enable him to assert or defend those rights. If the marriage take place before the suit is brought, it is not necessary to make the wife a party, unless the property involved in dispute is of such a character that it will survive to the wife in case of the husband's death. But as to the wife's real estate, the law is quite different. Marriage alone gives the husband no legal or equitable interest in her realty, unless a live child is born of the marriage, and then the husband acquires a life estate in his wife's realty, known as a tenancy by the courtesy. While at common law the husband was, in effect, the absolute owner of his wife's realty during his life, the courts of Chancery and the statutes have so stripped him of his common law rights, that, while his wife lives, he is but little more than her agent, or overseer. In all suits affecting her real estate, whether it be legal or equitable, the wife must be a party, and if her husband has not abandoned her, he, also, must be a party. If, however, as elsewhere shown, the husband has estopped himself by his own acts, or is debarred by lapse of time, from aiding his wife in recovering her realty, she may sue alone, by next friend, making her husband a defendant. On the death of the husband, intestate, his widow becomes reinvested with all those in action belonging to her at marriage, and not reduced to possession by the husband, and they belong to her absolutely, and do not go to his administrator, but if he die, testate, and specifically bequeaths them, they go to the legatee. Hence, in suits affecting choses in action not reduced to possession or bequeathed by the husband, the widow must be a party. So, on the death of the husband, the widow becomes as completely the owner and controller of her realty as though she had never been married, and her rights and duties in reference thereto are those of a single woman. Section 115. General rule applicable to assignments of property in litigation. Whoever succeeds to another's rights or property, whether by contract or by operation of law, ordinarily holds such rights or property subject to all the liabilities and burdens attaching to such rights or property while belonging to the former owner. The assignee stands in the shoes of the assigner. When a woman marries, the law assigns her personalty to her husband. When a man dies intestate, the law assigns his personalty to his administrator, and his realty to his heirs. When he dies testate, his will points out the persons to whom he has assigned his estate. If a person is declared a bankrupt, under a bankruptcy statute, the law assigns his estate to the assignee in bankruptcy, and such assignee is alone entitled to sue and be sued as to such estate, or to continue a suit begun by a bankrupt. So, if a person, prior to suit brought, transfer his interest in the property, or debt in dispute, he ceases to have any further interest in it, and his transferee must sue or be sued in his place. Hence, the general rule, before stated, which, when well considered, renders all other rules on the subject mere corollaries, readily ascertained and applied by reason. Section 116. Effect of voluntary alienation of property pending a litigation. The voluntary alienation of property, pending a suit, by any party to it, is not permitted to affect the rights of the other parties, if the suit proceeds without a disclosure of the facts, except so far as the alienation may disable the party from performing the decree of the court. Thus, if pending a suit by a mortgagee to foreclose the equity of redemption, the mortgagor makes a second mortgage, or assigns the equity of redemption, an absolute decree of foreclosure against the mortgagor will bind the second mortgagee, or assignee of the equity of redemption, who can only have the benefit of a title so gained, by intervening or filing a bill for that purpose. Generally, in cases of alienation, pendent elite, the alienee is bound by the proceedings in the suit after the alienation, and before the alienee becomes a party to it, and depositions of witnesses, taken after the alienation, but before the alienee became a party to the suit, may be used by the other parties against the alienee, as they might have been used against the party, under whom he claims. The same rule prevails where a vendee files a bill for a specific performance of a contract for the purchase of land against the vendor, and pending the suit he, the vendee, should sell to one or more sub-purchasers. In such a case, the sub-purchasers need not be made parties, and they would be bound by the decree in the suit. Generally speaking, an assignee, pendent elite, need not be made a party to a bill, or brought before the court, for every person, purchasing pendent elite, is treated as a purchaser with notice, and is subject to all the equities of the persons under whom he claims in privity. And it will make no difference whether the assignee, pendent elite, be the claimant of a legal or of an equitable interest, or whether he be the assignee of the complainants or of the defendants. Still, however, it is often important to bring such assignees before the court, as parties, by a supplemental bill, in order to take away a cloud hanging over the title, or to compel the assignee to do some act or to join in some conveyance, or to divest the title out of him, or to enjoin him from asserting such title, so that such assignee, although not a necessary party, may, at the same time, be a proper party at the election of the complainant. And an assignee after the bill was filed, but before the subpoena was served, has been held to be a necessary party. So, if the interest of a defendant is not determined, and only becomes vested in another by an event subsequent to the institution of a suit, as in the case of alienation by deed or devise, or by bankruptcy, the defect in the suit may be supplied by a supplemental bill, or a bill in the nature of a supplemental I-bill, whether the suit has become defective merely, or is abated 18 as well as become defective. For, in these cases, the new party comes before the court exactly in the same plight and condition as the former party, is bound by his acts, and may be subject to all the costs of the proceedings, from the beginning of the suit. But in case of a voluntary alienation by a defendant, pendent elite, the complainant has the right to ignore the transfer, and continue the prosecution of the suit as though no change in the defendant's interest had occurred. If the transfer is made by a complainant, and takes place after the bill was filed, the transferee may either continue the suit in the name of the original complainant for his benefit, or he may prove the transfer and have the suit revived in his name. If the transfer is made by a defendant after the bill was filed, and after subpoena to answer was served on him, the complainant need pay no attention to it, the doctrine of lis pendens applying, as shown elsewhere. But while a person can, either before or after suit, transfer a right, and thus relieve himself from all obligation to protect or enforce it any longer, nevertheless he cannot assign a duty or liability, so as to escape responsibility that or he can transfer a right, because that belongs to him, and is his property, but he cannot transfer a duty or a liability, for they belong to another, to whom he must render them. He may be indemnified against such liability, but the indemnifier cannot be made a party, on that account alone. A person who acquires an entirely new right or interest in the subject matter of the suit, by purchase during the litigation, may bring such right or interest before the court by supplemental bill, or original bill in the nature of a supplemental bill, and unless he does so he will not be allowed to take any benefit from the suit without the consent of the parties thereto. When a sole complainant, suing in his own right, loses all his rights in the litigation by an event after suit brought, by alienation, or otherwise, his assignee may file an original bill in the nature of a supplemental bill in order to assert and protect his rights. Article 9. Parties in particular suits. Section 117. Parties to suits in cases of trust. There are ordinarily four constituents in a trust. 1. A duty to be performed. 2. A person expressly or impliedly charged with that duty, called a trustee. 3. A person for whose benefit the duty is to be performed, called the beneficiary. And 4. Some property, the legal title to which is vested in the trustee, to enable him to effectually discharge the duty imposed on him. And in all suits affecting the trust, or the trust property, or the trustee's rights or duties, or the beneficiary's interests, both the trustee and the beneficiary must be made parties. The trustee must be made a party, First, because the legal title to the property is in him, and second, because it is his duty both to defend his title and to protect the trust and the beneficiary, and the beneficiary must be made a party because, in the eye of a court of equity, he is the real owner of the property, and is the person most interested in defending both the property and the trust. In suits by or against executors and administrators, who are express trustees, relative to the personal property vested in them, and in which the legatees, distributees, and creditors are beneficially interested, it is not ordinarily necessary to make such legatees, distributees or creditors, as the case may be, parties, if the suit relates exclusively to the personal estate, because the personal representative is authorized to sue or be sued alone, but if the suit relates to real estate, in which the devisees or heirs have an interest, legal or equitable, then the heirs or devisees interested must be made parties. In suits to set up and enforce an implied trust, if the implied trustee has acquired the absolute legal title, his vendor need not be made a party, but if the vendor has retained either the legal title or a lien, to secure purchase money, or for any other purpose, then the vendor must be made a defendant along with the implied trustee. In suits by or against executors, administrators, or other express trustees, all should be joined, except such as may have declined to qualify, or have died, or left the state. Section 118. When administrators, executors, and guardians should be parties, the general rules as to when administrators, executors, heirs, devisees, and legatees should be made parties, have been already given. Some special rules will now be given, applicable to administrators, executors, and guardians. 1. Administrators are the proper persons to sue, 1. For all debts due their intestates of every character whatever, 2. To recover all the personal property belonging to their intestates, at their death, and not exempt by law, 3. To enforce all mortgages, trust deeds, or other liens to secure debts to their intestates. 2. Administrators are the proper persons to be sued, 1. When a creditor seeks to recover any debt due from the intestate, 2. When there is a dispute as to the ownership of any personal property claimed by the intestate, 3. When a creditor seeks to have the land of a decedent sold to pay debts, 4. When damages are claimed for some breach of contract by the decedent, 5. When it is claimed that they have wasted the assets of the decedent, or not accounted for all the assets, or have failed to pay the creditors and distributees the amount due them, or in other respects have failed to do their duty, in which cases the sureties, on their official bond, may, also, be joined as defendants, and charged as such. 3. Executors are the proper persons to sue and be sued, 1. In cases where, if there had been no will, the administrator of the same estate would have been a proper person to sue or be sued, and, 2. In all cases affecting land devised to be sold where, if there had been no will, the heirs would have been the proper persons to sue or be sued. 3. If the executor fails to account for all the estate that came and should have come into his hands, fails to pay the legatees, distributees and creditors, having sufficient assets so to do, or in any other way violates his trust, he, and the sureties on his bond, are liable to the party or parties injured, and they may all be sued by such party or parties. 4. Guardians are necessary parties to all suits affecting the real or personal estate of their wards, whether such wards be minors, or persons of unsound mind. The guardian is the proper person to bring and defend all suits to which his ward is a party. If the suit affects only money of the ward which the guardian has loaned, the guardian may sue for it without joining his ward as a co-complainant, and if the suit be against a guardian for debts by him contracted, or for necessaries furnished the ward, the guardian should be sued alone, describing him as guardian. If the suit be to recover any specific personal property, or any realty, belonging to the ward, the suit should be in the name of the ward by his guardian, who in such suits is a next friend. And if the suit be brought to recover personalty, or realty, claimed by the ward, he and his guardian should both be parties, whether the suit be by them, or against them. Sometimes one guardian is compelled to sue his predecessor, in such case he can sue alone, describing himself as guardian, and need not join his wards as co-complainants. In such suits he may sue his predecessor or predecessors, and the sureties on his or their bond, or bonds, in the same suit. But frequently guardians violate their trust by failing to collect all of their ward's estate, or by failing properly to care for it, or failing to properly account for it. In all such cases, if the ward is a minor, he must sue by next friend, or by a new guardian, making the defaulting guardian and his sureties defendants, as shown in the next section. If the guardian has given more than one bond, the sureties on all the bonds may be made co-defendants. If the ward has attained majority, he can, of course, sue his guardian and sureties in his own name. Section 119. Parties to suits on official bonds. For any breach of an official bond of any officer, executor, administrator, guardian, trustee, or other person, required to be given by law for the security of the public generally, or of particular individuals, the party aggrieved may, by statute, without assignment, bring suit thereon for his use, giving security for costs, and being liable therefore as if the suit had been brought in his own name. The effect of this statute is equivalent to an assignment of the bond to the person aggrieved to the extent of his damage, not exceeding, of course, the penalty of the bond. By both statute and judicial interpretation, the person for whose use the suit is brought is the real complainant of record, and, in Chancery, is the real complainant in fact. While technically a suit on any of the above-mentioned bonds should be in the name of the state for the use of the party aggrieved, nevertheless the practice of suing directly in the name of the real complainant, and not in the name of the state, has long prevailed, and been directly sanctioned by the Supreme Court of the state. When, therefore, a ward, or a guardian or next friend for him, sues for the breach of his guardian's bond, or a distributee, legatee, or creditor sues for a breach of an executor's or administrator's bond, or any party aggrieved sues for a breach of any official bond, the party so suing will name himself as complainant, and make the party in default and the sureties on his bond defendants. If any of the sureties are dead, removed from the state, or insolvent, they may be left out of the bill so explaining, and the personal representative of a deceased surety may be made a defendant in his decedent's place, where a defaulting officer, executor, administrator, guardian, trustee, or other person required by law to give bond for the security of the public generally, or of particular individuals, gives more than one bond, he can in case of his default, be sued on all of his bonds, the bill describing the several bonds and dates thereof, and naming the several sureties on each, and making them defendants, so the court may determine the relative liability, if any, of such sureties. Section 120. Parties and suits concerning mortgages, trust deeds, and other liens on land. All persons having any interest, legal or equitable, in the land, or in the encumbrance thereon, are necessary parties, unless the object of the bill is a special foreclosure, in which case the complainants may omit both prior and subsequent encumbrances. The holders of encumbrances are proper persons to sue, 1. Whenever it is necessary to enforce their liens, in which case the mortgager, vendor, or other giver of the lien, if living, and his heirs if he is dead, must be made defendants, and 2. Whenever necessary to protect their liens against adverse claimants, in which case the same persons must be made defendants, and also the adverse claimants. Whenever a mortgagee of the absolute fee dies, his heir is a necessary party to a suit to enforce the mortgage debt, and his administrator is a proper party. If the mortgager dies, his heirs are necessary parties defendant to a bill to foreclose, but his administrator is not. On a bill to foreclose a mortgage or enforce a trust deed, neither prior nor subsequent encumbrances are necessary parties, but subsequent encumbrances are proper parties, and if the prior encumbrance is overdue, its holders are proper parties. If the prior encumbrances are not made parties, their rights will remain unaffected. As a rule, it is the better course to make parties of all encumbrances, prior as well as subsequent, to the end that the mortgaged premises may be sold with a clear title, and the proceeds divided according to priority of interests. If prior encumbrances object, which they will seldom do, the bill can be dismissed as to them, on their motion or demurrer, if the court so adjudge. It is often necessary to make prior encumbrances parties, in order to test the bona fides of their lien, and to ascertain whether all, or any part of their debt, remain unpaid. It must be borne in mind that while a suit to enforce a lien on real estate is a suit that deals with particular property, it is not a proceeding in rem, but in personam, and, therefore, no person is bound by the proceeding unless a party thereto, complainant or defendant. In a suit to foreclose a chattel mortgage, after the death of any party to the transaction, his administrator will, of course, stand in his shoes, whether as debtor or creditor. When a vendor's lien is in issue, both the party or parties claiming the lien, and the party or parties claiming the land, must be made parties, the former, or some of them, being made complainants when the object of the suit is to enforce the lien. If the vendor be dead, his heirs are necessary parties where the vendor retained the legal title, otherwise, they are neither necessary nor proper parties. If the vendee be dead, his heirs and widow are necessary parties in any event, but his administrator is not. The administrator is the proper person to enforce a lien on the death of the vendor, but if the legal title was in the latter at his death, his heirs must also be made parties. If otherwise, they are not proper parties. A recurrence to general principles will settle all doubts as to who are proper parties in case of liens, but the following general rules will aid. 1. The persons entitled to the proceeds of the debt secured by the lien are necessary parties, and should ordinarily be complainants. 2. The persons entitled to the residue of the proceeds of the sale of the property after the lien debt has been satisfied therefrom, are necessary parties, and 3. Any persons interested in disputing the right of any of the complainants to the debt, or the right of any of the parties to have the land sold, are necessary parties. In suits to enforce mortgages, trust deeds, and other liens, it may be stated generally: 1. All of the persons in any way interested, either in the particular lien sought to be enforced, or in the property charged with the lien, must be made parties. 2. Those entitled to the benefit of the lien, if their interests are harmonious, should join as complainants, making all others interested defendants. 3. If any who should be complainants do not give their consent to the suit, they must be made defendants. 4. All persons having a legal or equitable title to the property or the proceeds of the property charged with the lien, should be made parties, so that when the property is sold the purchaser may get a perfect title, and the proceeds of the sale be properly distributed among those thereunto entitled, according to their respective rights. But in all suits to enforce mortgages, trust deeds, vendors or other liens against real estate, whenever it is necessary to make their heirs of the debtors parties, his widow, if living, must, also, be made a party, because she has an interest in the surplus for her dower, and also for her homestead. If the lien is on a tract of land to which homestead rights may exist, the wife should always be made a co-defendant along with her husband, so that she may be bound by the decree, and thus be precluded from relitigating her homestead rights. Section 121. Parties in case of assignments. There are two sorts of assignments to be considered in this section. 1. Assignments of choses in action, and 2. Assignments for the benefit of creditors, and for convenience and clearness of statement they will be considered separately. 1. Parties in case of assignments of choses in action. The general rule prevails here, as in all other cases, that every party having an interest in the assigned debt when recovered, and every person liable to pay the debt, is a necessary, or proper party. If the debt be assignable by statute, or the law merchant, the assignee may sue in his own name, and his assigner is not a proper party, unless it is sought to set aside the assignment, or to hold him expressly liable for the debt, in which case he must be made a defendant. If, however, the debt is not so assignable, the assigner must be made a party, because the legal title is in him, and he may be joined as a complainant. If, however, the assignment is absolute, leaving no interest or title in the assigner, he need not be made a party. Bills of exchange, promissory notes, bonds and bank checks, are all negotiable, and bonds with collateral conditions, bills or note for specific articles, or for the performance of any duty, are assignable by statute. The assignees of all these instruments may sue thereon in their own names. 2. Parties in case of assignments for the benefit of creditors. Where an assignment is made by a debtor for the benefit of his creditors, if any creditor seeks to enforce the trusts, he cannot sue alone, but he must make all the other creditors, provided for in the assignment, parties, either by name, or by bringing the suit on behalf of himself and all the other creditors who may choose to come in and take the benefit of the decree. But the assignees themselves may file a bill relative to the trust estate, and to enforce its objects, without making the creditors parties, for the assignees, in such a case, are the proper representatives of them. Section 122. Parties to suits on written evidences of debt. In an ordinary action of debt, brought by a bill in Chancery, whether such debt be based on an express, or an implied, contract, and whether the contract be verbal, or written, and whether the debt be original, or obtained by assignment from another, the person or persons entitled to recover the money must sue as complainants, and the person or persons liable to pay the money, whether principals, endorsers, guarantors, or sureties, must be made defendants. If the debt is evidenced by a negotiable instrument, such as a promissory note, due bill, bill of exchange, or by an instrument assignable by statute, such as a bond with collateral conditions, or a bill or note for specific articles, or for the performance of any duty, an assignee may sue thereon in his own name. But if a debt not so evidenced is assigned, the assignee must join the assigner as a co-complainant, if he consent, otherwise he must be made a defendant, for the legal title to the debt is in the assigner. If, however, there be several assignments of a non-negotiable debt, only the original assigner need be made a party, unless the suit is brought to hold an intermediate assigner liable on some independent guarantee or contract to pay, in which case such intermediate assigner must be made a defendant. The payee of an order on another for money, may sue thereon, in his own name, either the person who drew the order, or the person on whom it is drawn. But he cannot sue the latter on the order unless he accepts it, and he cannot sue the drawer of the order, as such, without demand, protest and notice. He may, however, sue the drawer of the order on the original liability. In suits on promissory notes, due bills, checks and bills of exchange, all or any of the makers, including both principals and sureties, and all or any of the endorsers, may be sued by the holder of the instrument. And in suits for breaches of contract, any or all of the parties in default may be sued in the same suit, but all the persons injured by such breach must be parties, those not consenting to join as complainants being made defendants. When the obligation is to pay a sum of money to more persons than one, jointly, all of the payees must join in the suit as complainants, or if some refuse so to join, they must be made defendants, for, while the obligation is several as to the makers, it is joint as to the payees. However, in suits on obligations executed to one person for the benefit of others, such as suits on official bonds executed to the state, by officers, executors, administrators or guardians, and the like, any person belonging to the class intended to be secured by such an obligation, may sue thereon in the name of the payee, for his own use and benefit. In suits on bonds payable to the state, any person entitled to sue thereon may sue in his own name. Section 123. Parties where several are liable for the same debt. When several persons, either as principals or as sureties, or as both principals and sureties, are bound for the same debt, or duty, even though bound by different bonds or other instruments, they may all be sued, or any part of them may be sued, in the same suit, and all persons, or any of them, entitled to said debt or duty, or to any part thereof, may join as complainants in such suit, and if a part only of those entitled to sue, they may, and if an account is necessary, or if any trust is involved, should, make the remainder of those entitled defendants. Hence, in suits against trustees, executors, administrators, guardians, public officers and others who have given bonds and security for the proper discharge of their duties or contracts, all or any part of the sureties, on all or any of the bonds, on a default by the principal, may be made joint defendants to the same bill, and any or all of the parties secured by such bonds may be joint complainants in the same bill, but if a part only of those entitled to sue by reason of the particular default join in the bill, the remainder of those entitled should be made defendants. If any of the obligors on said bonds are dead or insolvent, they, or their personal representatives need not be sued, but the fact of death or insolvency should be stated in the bill as a reason for not suing them, or their personal representatives. Section 124. Parties to suits to collect debts. Where other creditors have concurrent rights. In suits to collect a debt from a fund in which other creditors have concurrent rights, the parties who sue must file their bill in behalf of themselves and of all others entitled to share in the fund. This is one of the few exceptions to the general rule, requiring all persons having an interest in the subject matter or object of the suit to be made parties. The reasons for this exception are: 1. The difficulty, and often the impossibility, of ascertaining all who are interested; 2. The increased costs that would result from allowing each creditor to institute a separate suit; and 3. Inasmuch as the bill is filed in behalf of all the creditors, those not named as such can have themselves made parties on petition at any time before the fund is distributed, and, as a consequence, are not injured by the preceding. Accordingly, when bills are filed by a creditor or creditors, 1. To sell the lands of decedent to pay debts, or 2. To distribute a trust fund, or 3. To wind up an insolvent estate, an insolvent partnership or an insolvent corporation, or 4. To set aside a fraudulent conveyance of property made by a decedent, or 5. To have an administrator appointed. In any and all such cases, the bill must be filed on behalf of all other creditors entitled to be paid out of the proceeds of the fund, or property, sought to be thus administered in the Chancery Court. All persons having the legal title to the said fund or property must be made defendants. 1. If the suit is brought to sell the lands of a decedent to pay debts, his heirs and administrators should be made defendants, and if the bill, also, seeks to set aside a fraudulent conveyance by the decedent, the fraudulent vendee must be made a defendant. 2. If the suit be brought to wind up an insolvent partnership or insolvent corporation, in case of a partnership all of the partners, and in the case of a corporation, all of the officers and directors, must be made defendants. 3. If the suit is brought to distribute a fund in the hands of a trustee, he should be made a defendant, and if his official sureties are sought to be charged, they, also, must be joined as defendants. It must be remembered, however, that whenever one person sues on behalf of himself and others, care must be taken that this person has a clear right in himself, for, if he is not really entitled to sue, the suit cannot proceed, and must be dismissed. In suits of this nature, inasmuch as the complainant acts on his own motion, and at his own expense, he has the absolute control of the suit, and can dismiss it at his pleasure, at any time before a reference to the master, or before the rights of others in the suit have vested in consequence of some affirmative act on their part approving the suit, joining in it, or accepting its benefits. A suit by one in behalf of himself and others in the same right, will be dismissed as to all if dismissed as to the one in whose name it is brought, unless someone in the same right, who has become a party by petition to take advantage of the bill, offers to continue the prosecution of the suit, and tenders a proper prosecution bond to cover all costs accrued and to accrue. Section 125. Parties to suits to recover land, and to remove clouds. The Chancery Court now having jurisdiction to determine the legal title to land, in a suit concerning the legal title only, the rule as to parties and similar suits at law will, no doubt, apply in Chancery. Hence, in suits to recover land in the Chancery Court, on the strength of the complainant's legal title alone, no party having an equitable interest is a necessary party. For this reason, a trustee, he having the legal title, may sue alone to recover the land conveyed to him in trust, and the beneficiaries are unnecessary parties. If, however, he should refuse to sue in a proper case, the equitable owners may sue, using his name as complainant. So a mortgagee may sue either the mortgager or a stranger in order to recover the land mortgaged, but in the former case, he would probably be met by the mortgager's equities. In suits to recover real estate, all who claim the property under the same title should join as complainants, and those in adverse possession and all others who claim adversely to the complainants, should be made defendants. Ordinarily, a mere claimant not in possession need not be sued when not exercising any acts of ownership, but if his claim constitutes a cloud on the title of the complainant, he may be sued, even though not in possession, and not actually exercising any visible acts of ownership. So, a remainder man may maintain a bill to remove a cloud from his title. None but tenants in common, and their privies in estate, can join in bringing an ejectment bill. Persons claiming under conflicting titles cannot join in such a suit. In a court of law, a complainant, in order to avoid the question of champerty, may join his grantor, or his grantor's grantor, or both, or any other privy in estate, as co-plaintiff, with their consent, but this cannot be done in Chancery, as it would make the bill champertous on its face. In an ejectment bill, the complainants will not all suffer defeat, if it appear at the hearing that some of them have no title, or are barred, or estopped. In such case, the bill will be dismissed only as to those who fail, and a decree will be rendered in favor of those who make out their case. This sort of suit is both joint and several, and all the owners, if more than one, may sue, or any one or more of them may sue, and where less than all sue, it is not necessary to make the other tenants in common defendants. But if the bill seeks both to recover the possession and clear up the title, and also to have the land sued for partitioned, then all the tenants in common must join in the suit as complainants, or, those not joining as complainants must be made defendants, the bill setting forth the rights of the latter, and praying the same relief for them as is prayed for the complainant. This is the better practice, as it removes all grounds for any future litigation, and determines all matters of controversy in one and the same suit. In suits to recover land, the tenants of the defendant are not necessary parties, but they are proper parties, and, if they are in actual possession and the landlord is not, they are necessary parties. If there is any danger of a tenant resisting the enforcement of a decree against his landlord, or if there is any doubt about his being really a tenant, he should always be made a co-defendant with the landlord. Inasmuch as the wife has an interest in the homestead that courts will enforce, and especially courts of equity, it is often prudent to join the wife as co-defendant with her husband, in any suit brought to recover land that would be a homestead if the title, legal or equitable, were in the husband. So, in suits to enforce all liens, except vendors' liens, it is the better practice to join the wife as defendant with her husband, if any homestead rights are involved. Section 126. Parties to suits to partition or sell lands. In suits for the partition of land, or for its sale because incapable of advantageous partition, all the tenants in common must be made parties. If any of them are married women, their husbands, also, must be made parties, and if any are minors or of unsound mind, their guardians, if they have any, must, also, be parties. In a bill for partition, or for sale for partition, persons who have liens, encumbrances, life estates, remainder interests, dower or homestead rights, or other claims on the property, must be made parties. They or any of them may join as complainants, but if they do not consent so to do, they must be made defendants. The object the law and the court have in requiring all persons to be made parties who have legal or equitable interests in lands to be sold, is to give a good title to the purchaser, and thereby not only realize the largest possible price for the property, but also prevent any further litigation over the title. The holder of the legal title in a case of trust, and the contingent remainder men, if any, must be made parties. Sales for partition, however, may be made without reference to the encumbrances and subject thereto, in which case the rights of the encumbrances are not affected in any way by the sale. Those desiring to have the land partitioned, or sold for partition, should all join as complainants, making all the other parties interested defendants. Ordinarily, minors and persons of unsound mind should be made defendants. When a married woman is non-compos, she must be made a defendant. Minors, however, may be complainants. A bill to sell the real or personal estate of a minor or married woman for their education or maintenance, or for reinvestment, and not for partition, must be filed by the husband of the married woman, and by the guardian of the minor, the wife and the ward being, respectively, made defendants. In such case the infant, if over 14 years, and the married woman, must answer the bill in person. The married woman must be represented by a next friend, and the minor by a guardian ad litem, both to be appointed by the court. The court will also appoint counsel for them, if they have none. Section 127. Parties to suits affecting equitable property. In equitable property the legal title is generally in one person called a trustee, and the equitable title, or beneficial interest, in another person called the beneficiary. And, in all suits in Chancery to reach such property, both the trustee, or legal owner, and the beneficiary, or equitable owner, must be made parties. The trustee can sue alone, generally, when it is necessary to protect the legal title, but in any suit affecting the equitable title, or the beneficial interest, he must join the beneficiary with himself as a co-complainant, or must make him a defendant. So, on the other hand, the beneficiary must always make the trustee a party in any suit he may bring affecting such property. A creditor who seeks to reach an equitable interest, or estate, or to enforce a lien or equitable interest of his own, must make the owner of the legal title a party, as well as the owner of the equitable interest. Article X. Parties and suits by and against the state, counties, cities and corporations. Section 128. Parties and suits by and against the state. No court of the state has any jurisdiction of any suit against the state, or against any officer of the state, acting by authority of the state, with a view to reach the state, its treasury, funds or property, and if any such suit should be brought it shall be dismissed as to the state or such officers, on motion, plea or demurrer of the law officer of the state, or counsel employed for the state. Suits by the state are instituted in her name, by her attorney general, or by her district attorney, as occasion may require, without security for costs. If a suit is brought by the state in the interest of any person the bill so states, such person being named as relator. Where any person has been aggrieved by the breach of any bond executed to the state to secure performance of official duty, he may sue thereon for his use in the name of the state, on giving security for the costs. The state is not responsible for any of the wrongs or defaults of her officers or agents. But officers of the state may be sued when her property is not sought to be reached, and a county trustee may be enjoined from collecting a state tax under a void process. Section 129. Parties and suits by and against counties. Every county is a corporation, and the justices in the county court assembled are the representatives of the county, and authorized to act for it. A county sues in its own name as does any other corporation, and does not sue in the name of its justices. Suits may be maintained against a county for any just claim, as against other corporations, and process is served on the presiding officer of the county court, who is authorized to employ counsel to defend such suits. But a county is not liable for the neglects of duty of its officers. Suits for the use and benefit of a county against a delinquent officer, or his sureties, are brought in the name of the state for the use of the county. If the suit against a county seeks to prevent a county warrant being issued or paid, the county trustee should be made a defendant along with the chairman or county judge. Section 130. Parties and suits by and against municipal corporations. Corporations are of two kinds under our laws: 1, municipal, and 2, private. Both kinds are creatures of the legislature, directly or indirectly, and neither sort has any powers which the legislature has not, directly or indirectly conferred, and, in case of municipal corporations, may not take away. Municipal corporations include all the cities, towns and taxing districts chartered under the laws of the state. They sue, and are sued, in their corporate name, and their power to sue, and their liability to be sued, are fundamental. Their power to sue is coextensive with their rights, and their liability to be sued is coextensive with their duties. When sued, the subpoena is served on the mayor, or other head of the corporation, and they cannot be sued out of the county in which they are situated. Section 131. Parties to suits by and against private corporations. A private corporation is a person in law, and is sometimes called an artificial person to distinguish it from a natural person. Its charter and the general laws circumscribe and define its rights, powers, Duties and liabilities. A private corporation has a legal name, and sues and is sued by such name, but, like a natural person, it may have another name by which it is known, and if sued by such other name the proceeding is valid. A private corporation, like a natural person, may sue anyone indebted to it, or having its property in possession, or interfering with its property, rights or duties, and may be sued by anyone to whom it is liable ex contractu or ex delicto. In the same manner a natural person is sued, and the subpoena is served ordinarily upon its chief officer, if he is within the jurisdiction, and if not the statute makes other provision for service of process, as hereafter fully shown.